Good afternoon, everyone. Welcome to another question and answer session. My name is Samara Belitzky. I'm a lawyer at Samfiru Tumarkin. I work out of the Ottawa office, but I practice throughout all of Ontario. So I'm here once again today to answer all of your questions related to employment law, workplace issues. So any type of issue you're having in the workplace, any employment issues, whether it be a termination, severance questions about safety in the workplace related to COVID or perhaps not related to COVID. I will be here for the next half an hour to answer those questions. It seems like over the last few weeks, vaccinations are kind of top of mind for everyone. We've been getting a lot of questions about COVID-19 vaccinations and mandatory vaccination policies in various workplaces. So I'm sure we'll have some of those questions today as well. So whatever it is that you've had on your mind, whether it be for yourself, a family member, a friend, I will be here to answer those questions. So don't be shy, send them in. I will get through as many as I possibly can. And we'll go from there. So I already have a bunch of questions coming in, so I'll get right into the questions. Just bear with me. So I have a question from Vaughn on Facebook who says, I have a bunch that I have accumulated from many people who contributed to my list of questions. Oh, okay. So Vaughn, ask away, whatever it is. I would just ask that you ask one question at a time so that it's easier for me to read up on the screen. But please, we welcome all of your questions. So please go ahead. I'll just scroll through the rest of the questions I'm getting here. So I have a question from Michelle on Facebook who says, I work at a retirement home and will be put on unpaid leave of absence. How do I get my severance? So with respect to a long-term care home, there are specific mandates that the government has put in place. So it's very important to keep in mind that every single workplace is different and every industry is different. And so in terms of kind of a blanket answer of if you're owed severance, if you're not owed severance, what type of termination can an employer apply, what can they do, what are your rights as an employee, that will all be fact dependent. So there is no kind of rule of thumb or one size fits all when it comes to these issues. It will always depend on your particular situation, your particular circumstances. So it's really important to always get advice from an employment lawyer so that we can actually analyze your particular circumstances and give you the proper advice. So with respect to Michelle's question, in terms of a long-term care home, the government has actually put into place mandates, legal mandates for certain industries like healthcare and long-term care homes. So in a long-term care home, which is specifically what Michelle is asking about, the government has put a directive into place which states that all of the employees have to be vaccinated or, in the alternative, submit to rapid testing. So that's a law that was created by the government. It's not the employer that's creating those policies, unlike a lot of other private businesses that are now implementing mandatory vaccination policies. The long-term care homes, the hospitals, anything to do with long-term care and healthcare have actually been now forced by the government to implement these terms. And so if you're in a situation, Michelle, or anybody else in similar circumstances where your employer is simply applying the law that the government is forcing them to implement, then and you are not going to agree to be vaccinated for personal reasons, or you will not submit to the alternative, which is the rapid testing. In a situation like that, there would not necessarily be an entitlement to severance. Again, it depends on the circumstances, but that would be because it's not the employer that's implementing the policy, but it's the government that has actually changed the law. And there must be a compliance with the law. So those are very, very particular exceptional circumstances where if the employer falls under those industries that the government is mandating it in and has offered either the vaccination or the alternative, which is the rapid testing, and the employee refuses both of those things, then the employer actually has no choice but to let the employee go in a situation like that, which would mean that it's in other words, out of the employer's hands because the government is forcing their hand. And that would be a situation where it wouldn't necessarily be a regular termination where severance would be owed. In many other circumstances where the government has not mandated vaccination in the workplace and where an employer has simply implemented their own policy, those situations are different. And in the vast majority of those situations, severance would be owed in those. So, Michelle, what I would say is, if you're not sure, where your employer falls in terms of these government mandates, or if your employer has not offered you the alternative of rapid testing, that would be a situation that we'd want to look at more closely. And feel free to contact me or any of my colleagues. You can go to employmentlawyer.ca, or you can email us at help@employmentlawyer.ca to get in touch with us so that we can assess your situation in more detail, because it may be that you are owed severance depending on the circumstances. So we'd have to take a more detailed look at that because every single case is different when it comes to these issues. So I'm scrolling through the rest of the questions here. I have a question from Rob on Facebook who says, can my employer send me home for not being vaccinated? So I just touched on this a little bit, but in essence, it depends on what your workplace is, the industry, the actual workplace itself. There are many circumstances that lend to us being able to assess whether a termination might be justified or an end of the employment relationship may be justified. In general, an employer should not necessarily be terminating somebody because they've chosen not to be vaccinated. However, that doesn't prevent them from doing it. And so what I'd say to you, Rob, and this is what I've said to lots of people over the last few weeks, is if your employer is implementing a mandatory vaccination policy where the policy is either you get vaccinated or we're going to let you go, the only way to prevent them from letting you go is to get vaccinated. So there is no way, especially as an employment lawyer, for us to stop the employer from letting you go. And so if you are in that type of situation, which I understand many people are in that situation right now, unfortunately, there isn't a way to stop that from happening. There are ways to deal with it after the fact. And if you are let go, Rob, and you're not in any of the industries where the government has mandated the vaccination or in the alternative, the rapid testing, then in the vast majority of cases, again, fact dependent on where you work, but in the vast majority of those situations, you will be owed severance pay. So it's not that we can stop them from letting you go, because this is the way employment law works. Most people think that employment is always guaranteed. Unfortunately, it's not. An employer can decide to let somebody go at almost any time and for almost any reason. And then the question becomes, have they offered you enough notice and or severance pay? So if you are somebody who is in this type of situation where you've been essentially given an ultimatum, certainly after the fact, if you choose not to be vaccinated or agree to any sort of other alternative that's being offered, you are likely owed severance pay, depending on the circumstances, but mostly in the situations that we're talking about here, you would be owed severance pay. It's a question of how much, and that will depend on your age, your length of service, your position. All the different factors that we look at will impact how much severance pay you could be owed. And that's where you would contact us. So at this stage, we can give you advice, absolutely, but I cannot stop an employer from letting you go. I can help you deal with it after the fact, and I can pursue a severance package for you. So in terms of, your original question, Rob, of, can they send you home? They can, in the sense that nobody can stop them from doing that. It's a question of what happens after that. And if they are, sending you home, is that a termination? Are they offering you a severance package? Are they letting you go for cause, which means they're not offering you a severance package? These are all the questions that we need to look at in terms of the aftermath, in terms of figuring out what it is that we can do to assist you. So Rob, if you are in a situation where you already have been sent home, whether it's that terminology, you've been sent home, you've been put on a leave, you've been terminated, whatever the case may be, get in touch with us. We can assess the situation for you, let you know where you stand, based on your particular circumstances at your workplace. And then we can go from there in terms of pursuing a severance package. I have a question here from Stephanie on Facebook who asks, am I legally allowed to hire a lawyer if I'm already unionized? So the law does not prevent you from hiring a lawyer, to be very clear, but the law does not allow you to sue your employer in court. So you can hire a lawyer can give you advice, but that's about all that we'd be able to do in a situation like yours where you're unionized, because the way that the law works is in exchange for being unionized, essentially you give up your right to be able to have a private lawyer represent you and go through the court system. Instead, you have to go through the arbitration system with your union. So you certainly can get advice from a lawyer. And sometimes I do speak to people who are unionized because they may understand that I can't represent them, but they want to speak with me to get some objective legal advice on their situation. That we can do, of course, always with the understanding that we can't do much beyond that. It would really just be the purpose of providing advice. So in your situation, Stephanie, I don't know what the issue is specifically, but you would have to go through your union. So if you're dealing with an issue in the workplace, you should contact your union and you should get your union involved to be able to assist you and represent you, because that's the union's job. That's their mandate. If ever you wanted to receive independent advice about the situation from an employment lawyer, certainly we can do that. We can assist you in that regard, but we wouldn't be able to represent you or, for example, take whatever issue you're having to the court system. That is what is not legally allowed. Okay, so I have a question from Vaughn on Facebook who says, as an employee of an employer who is supposed to enforce the health passport mandate, do I have to legally enforce this? Is it actually a law? Do my customers have to abide, or am I discriminating? So when it comes to the vaccine passport, if you work in any of the industries that have now been mandated by the government to verify this, again, it's a government mandate. The government has made it the law. So as an employer, your employer has to comply with that. Otherwise, they're breaking the law. They have no choice in the matter if they want to operate their business. They either shut down their business or comply with the law. Those are their options. And so as an employee of that employer, you're mandated by your employer to do the same. So the employer is mandated by the government to check for the vaccination passport and ensure that they're complying with the law. And as an employee, your mandate is the same. If an employer has to do it, and part of the duties that you have assigned to you are to check those vaccine passports or check for confirmation of vaccination, for example, then that becomes part of your duties, and you do have to carry those out. If you refuse to carry out those duties, it can be insubordination, which can lead to a termination for cause. Meaning if you engage in acts of insubordination where you're being given a direct order from your employer and it's the law, and you choose not to carry those out, that's insubordination. And more than one or several instances of that could lead to a situation where you're let go without severance pay. So you want to avoid that situation, specifically in the circumstances I'm talking about. As long as the conduct is lawful, which it is because the government has made it the law, you would have to carry out those duties that are being assigned to you as an employee. And then I'm just going back to the second part of your question here, Vaughn. Do my customers have to abide by it? They do if they want to frequent the establishment, again, because that's the law. The government has changed the law. This isn't something that a private business is implementing on its own. It's something that the government has implemented as a mandate that has to be complied with. So it's not going to be looked at as something that is discriminatory unless somebody has an exemption for reasons under the Human Rights Code. So, for example, if there is a medical exemption where somebody is allergic to one of the ingredients in the vaccine, or maybe somebody received the first dose, had a bad reaction to it for some reason, and their doctor has the opinion that it would be dangerous for them to take the second dose. Those are just a couple examples of medical exemptions that would exempt somebody from having to show the vaccine passport, or having to have a vaccine in order to frequent an establishment under the government's law. So there are exceptions, but they are very limited. And so for those exceptions that are actually recognized at law, there does need to be an accommodation there. I have a question from Mark on Facebook who asks, if I am terminated for non-compliance for a mandatory vaccine policy, will I qualify for EI after my severance period is over? That's a very good question. It's very premature in the sense that we're only starting to see terminations occur for this reason now. So we actually haven't seen whether or not people are being denied EI benefits yet. I'm sure it's going to come in the following weeks. But what I can say is it will depend on the type of termination or the reason for the end of the employment relationship, just like it would in regular circumstances. So if it's a termination for cause, the employer terminates employment for cause, meaning they're alleging misconduct. In those types of situations, you wouldn't qualify for EI benefits initially. So Service Canada would likely reject the application, and then you can appeal it. And so if that happens in a situation where there was no cause, which does happen to some of our clients, we can assist them in appealing that decision, and then they will get EI benefits if there wasn't actually cause. So EI, Service Canada will look at that and will actually go to the root of the issue and see if there actually was cause for termination or not. Another circumstance in which EI will not be approved is if somebody resigns from their employment. So again, if on its face the employer puts on the record of employment that it was a resignation, even if that's not true, sometimes you'll be denied at the outset, and then when you provide more information, you'll then be approved. So in these types of cases, with respect to Mark's question, a lot of the situations that we're dealing with are situations where there wouldn't be cause for termination and it wouldn't be a resignation. So in those situations, not only would the severance be owed, but in those situations, similarly, you would or you should be entitled to EI benefits as well. So again, it's one of these situations where it's fact dependent. It will depend on your particular workplace, what the government has mandated for it, if anything, and the reasons for why the employment relationship came to an end. So we'll have to look at that more closely. But if you're in a situation where you are let go for not complying with a mandatory vaccination policy, Mark, get in touch with us right away so we can assist you, both with severance as well as potentially the EI issue down the road. I have another question here about unionized employees. So Tina on Facebook is asking, if unionized, can one consult a lawyer after exhausting the grievance process? So once again, you can always consult with a lawyer at any point in the process. Before you go to your union, after you go to your union, while you're dealing with your union, you can always consult with a lawyer. But what most lawyers will tell you, or most law firms will tell you when you call them, is that there isn't very much we can do for you. Because we want to make sure that you understand that if you're moving forward with a consultation for which you will be spending legal fees, there needs to be a clear understanding that we can give advice, but not much more beyond that. And so at least at our firm, we're very upfront about that because we want to make sure that if you're unionized, you understand that you're limited in what a lawyer can do for you. In terms of the grievance process itself, you can consult with a lawyer if the grievance process has concluded. But again, there is very little that a lawyer would be able to do for you at that point because the grievance process will either end in a settlement, which is final and binding, or it will end in a decision from an arbitrator, much like a court decision, and that decision from an arbitrator will be binding as well. And so if you're unhappy with the result of a grievance hearing or arbitration, you really do have to go through your union to deal with that issue because there's only so much that a lawyer would be able to do. We can give you our opinion, we can give you our advice, but that's all that we'd be able to do for you in a situation like that. Okay, I have a couple other questions here from Vaughn on Facebook. What's the best way to handle an employee who is threatening to fire me if I don't take the jabs? I assume you mean the COVID-19 vaccination. Do I get it in writing first from them and then take to a lawyer? So in terms of there being a threat to let you go, the employer has to make a decision. They're either going to allow you to keep working there without a vaccination or they're not. It's one or the other. And that's something that will have to come to a head, and maybe putting it in writing will help get that to a resolution or to a head, meaning they either decide they're keeping you or they're not. But that's what needs to happen in order to move forward in the process. So there is no kind of legal recourse right now. You'd have to have the end of the employment relationship take place first. So, in terms of a threat, it can be an empty threat. But if they're serious about it, then they should, as a matter of proper policy, be putting something in writing to you where they outline that they have a mandatory vaccination policy, and if you don't comply with it, X, Y, or Z may happen. That's the standard practice, and that would be kind of the proper employment law practice from an employer perspective, if that's something that an employer is contemplating doing. And then with respect to any questions about issues resulting from the vaccination, an employer that implements a mandatory vaccination policy would not be liable for the resulting damages, if any, that come from the COVID-19 vaccine. Just like any other case or any other issue, if you experience a negative experience or side effects from anything, any type of product, it's the manufacturer of that product that would be liable for any negative consequences, and not the employer. Okay, so I have a question from DeMilo on YouTube, who says, my friend works for LAUSD, and I'm not sure what that abbreviation is for, but assuming that it's a Canadian entity, they told him if he doesn't get vaccinated, they would put him on unpaid status and that he would not be able to use vacation time or sick time. What options does he have? So if somebody is put on unpaid leave because they won't get vaccinated, and the employer is mandating it in the workplace, there are a few different options for people who are in situations like that. And it will depend on the job, the workplace, and other circumstances. So if you are in a situation like that, it's really important to get in touch with us. Again, you can go to employmentlawyer.ca. All of our contact information is there. You can contact any of our lawyers, or you can send an email to help@employmentlawyer.ca, and somebody will get back to you in order to set up a consultation with one of our lawyers so that you can get advice about your specific situation. Because depending on the circumstances, an unpaid leave may mean that it's actually a constructive dismissal of your employment, where your employer is forcing you not to come to work, they're not allowing you to work, they're not paying you. And so that can result in a constructive dismissal where you'd be owed severance. Something else that you could potentially do is go and get another job temporarily while this is happening, depending on the terms and conditions of your employment. So it really does depend on the circumstances. There is no one size fits all. Every situation is different. And so I do recommend that, DeMilo, your friend, get in touch with us, because he or she should be able to go through their options and make an informed decision about how they want to deal with this. Because there are certainly options. If you're in a situation where you're put on unpaid leave because you won't get vaccinated, where it is mandatory, you do have options, and there are ways that we can pursue severance. In the vast majority of cases, you will be owed a severance package. So it's really important to consult with a lawyer so that you know what your options are. I have a question from Christina on Facebook who says, my fiance is a chef and his employer has decided now that all staff must be vaccinated or do daily rapid testing. Does he have any recourse? What would happen if they terminate him? So Christina, with respect to this kind of set of circumstances, the rapid testing could be considered a reasonable alternative to the mandatory vaccination. So we would have to look at things like, what does the workplace look like? How close is he to his coworkers? What is the proximity to other people within the workplace? Have they had outbreaks within the workplace that they're having a hard time controlling? So all of these factors would be part of the analysis in terms of deciding or determining, rather, is the rapid testing a reasonable alternative? Is that something that is reasonable within the workplace to ask the employees to do? And if it is reasonable, depending on the circumstances, and your fiance does not comply with it, then there might be a situation where he is let go. If it is not reasonable as an alternative in terms of the rapid testing, and your fiance is let go because he won't comply with an unreasonable request from the employer, then certainly there's going to be legal recourse there. And in terms of the legal recourse, it will be severance for sure. And then there is potentially other types of damages that would be available depending on the circumstances. So if he is concerned about losing his job, he or she, I should say, they may want to speak with a lawyer first in terms of trying to determine ahead of time, before he's potentially let go or she's potentially let go, what is reasonable and what's not. We would look at those circumstances in order to determine, do they have a legal leg to stand on in terms of refusing this rapid testing? And that way they may be able to get ahead of it. And we may be able to explain that if you don't comply with this, you may be let go and you might not have much recourse. Or if you are let go, you will have recourse and we can assist you with that. And that will help him or her make an informed decision in terms of deciding what to do here. Because in the vast majority of cases, there isn't a way to prevent an employer from letting you go. But in this case, because there's an alternative being offered, if you get the legal advice now, you may be able to prevent that from happening if that's something that, they're interested in. So definitely get in touch with us and we can look at that further and give you more comprehensive advice. I have a lot of questions coming in here, so I'm just trying to scroll through to get to as many as I can. Just bear with me. We're almost at the end of our time here, but I will answer just a few more questions because we have so many. So I have a question here from Derek on Facebook who says his company is non-union and will be mandating the vaccine soon. The company wants all of the employees to comply or be subjected to multiple weekly tests and make us pay for this testing, as well as sign liability forms. Thoughts? I have lots of thoughts, Derek. So in terms of mandatory vaccine policy with an alternative for testing, no issue with that necessarily, as long as it's reasonable. So a lot of employers, from what we've been hearing, have been implementing mandatory vaccine policies, but with the alternative of rapid testing. And depending on some of the factors I just mentioned, what the workplace looks like, what your job is, how the testing is being done, we're hearing from some people that these companies are simply providing the test to the employees to take home with them. The employees are doing it themselves and then submitting it. In a situation like that, it's kind of smooth and simple and the employer's paying for it. Those circumstances are likely going to be reasonable or found to be reasonable for mandatory testing as an alternative to the vaccine. But very importantly, the employer has to pay for it. The employee does not have to pay for any of this, especially, the testing you mentioned. It's not very expensive. There should be no reason for why an employer can't pay for it. But more importantly, the law mandates it. So there's no situation in which an employee would have to be paying for the COVID testing that an employer has put into place. So that certainly is something that you can push back on, assuming you have no issue with the testing and it's just the cost that's the concern. You can certainly push back on that. And if you do encounter further issues with it, Derek, definitely get in touch with me or any of my colleagues. We can assist you with that. The liability form, I'd have to see it. So it's very hard to address, what the contents might be and what the liability is for. But if you did want to have that reviewed, certainly get in touch with us and we can take a look at that and let you know where you stand and if it's something you should or shouldn't sign. I definitely wouldn't recommend you sign any sort of release of liability without getting advice from a lawyer first. Okay. I'm not going to be able to get to the rest of these questions, unfortunately. We've had so many questions come in that I actually am not able to scroll fast enough to keep up with them. But what I would say is anybody that hasn't had their question answered, you can contact us. You can join us again next week. We have several question and answer sessions live next week as well, where all of your questions can be answered then. Or you can contact us directly at our website, as we mentioned before, at employmentlawyer.ca or emailing help@employmentlawyer.ca. So we would love to answer your questions. Unfortunately, we're out of time today and I just couldn't get to all of them. But thank you so much for joining us. Thank you very much for your questions. And I will see you in the next question and answer session. Bye.